the American constitutional, the American judicial oath is a little bit different to the British one, but I think it still means the same thing essentially, or near enough the same thing. They've got this constitutional oath as well, which says that they've got to defend and protect the United States of America. So you could probably say that by that oath, I mean, they probably view Assange as an enemy, although I don't think Robert F. Kennedy sees him as an enemy. Although those soldiers that were, filmed were acting on behalf of the United States, supposedly against an enemy. Although Assange was critiquing their conduct and behaviour, I suppose, in a way, disclosing it. But for the judicial oath, this has been going since 1789. The British oath does say the word favour in it, but it says here, I do solemnly swear or affirm that I will administer justice without respect to persons. It says without respect to persons. So that means that they've got to do justice based on the law and the evidence. I think that's pretty much the same as what the current jury oath they've got, that I will, in England, the current jury oath is that I will try the defendant based on the evidence, right? So without respect to the person means that they will do justice by the letter of the law and by the evidence, right? And then it says, and do equal right to the poor as the rich, and that I will faithfully and impartially discharge and perform the duties incumbent upon me as, then in the name, according to the best of my abilities and understanding, agreeably to the constitutional laws of the United States, so help me God. So this impartiality, that means that you don't have a personal opinion other than what the law says and the evidence presents, right? Now, this is the problem. The United States have just done a deal with Assange. They've done a dealing with him. They've basically bargained justice. They've bargained for justice. They've made deals for justice, and they wanted Assange to. They personally wanted Assange to enter a certain plea and made him agree to it or persuade him to. Now you can only do that if before a case has been heard and before evidence has been laid and before justice is done, you're actually trying to get someone to do your opinion. Now, I know that you have someone has to have some kind of evidence to bring the charge, right? Someone has to lay evidence so that there's law there and there's facts there for a lawful due process. But that has got nothing to do with the freedom, the free will of the defendant to decide themselves of their own free volition whether they want to plead guilty or not, right? And based on whether they think they're guilty or not, or on what they think the truth is from their perspective, right? So as far as the judge in America is concerned, or the prosecutor or the police officer, Assange's plea is actually none of their business. It's not of their right business or concern. Their concern is the letter of the law. When someone appears, it is to present a case and hear a case based on law and the evidence, right? That is the job of the judges in America, right? You see, without respect to the persons, right? Well, that is Assange's own without respect to people, basically, which means Assange and his own right, his own opinion on his own guilt or not on his own right, that's his business, that's his plea. And obviously, the judge is a person without respect to the judge's self, or the judge's own opinion, or the police officer's own opinion. Now, the police officer and the judge and the Crown prosecutor have their own opinion in doing their duty when they assess the evidence. I'm assessing the evidence. I'm assessing the evidence. I'm bringing the charge. I'm bringing the charge. I'm presenting the case. I'm trying the defendant. At what point is any of that telling Assange how he should or should not plead? It's not. Because that is his right reserved to himself. You don't do deals in justice. In England, it's called a favour, right? You know, if you plead guilty, you know, we'll let you off. We'll give you a shorter sentence. That's illegal, because what it is, it's not justice. It's actually a bargain. It's a deal. Justice is not a deal. You can't do deals in justice. When I was in the police station being questioned, I was speaking about deals, you know, because I knew about these assisting offenders, you know, when they get, you know, whatever. Although, you know, I was protected by rights anyway. I was illegally prosecuted. But I was like, you know, I'll do a deal. And they go, no deals, no deals, no deals. Oh, you know, no deals. When they don't want to do any deals, they don't, no deals, right? We don't do deals. You know, it's like, you know, it's like a sign on a shop, isn't it? You know, and you change it says, like on open all hours, you know, closed. We are closed. And then the next morning turns the sign round. Oh, we're open. No deals. No deals. We don't do deals. No deals. No deals. You know, Tyson, no deals, Tyson. Next morning, oh, now we're open for deals. Come on, Mr. Assange, sit down. We'll do you a deal. We'll you know, if you know, we'll do you a deal. You know, so it actually is illegal in the American law, because it's you're getting into the defendant's own. You know, it's in a way, really, in a way, it's kind of similar to it's like the prosecutor or the police officer or even the judge basically you know, doing, you know, starting to get involved in the Assange's defence material, or if Assange's barrister or lawyer was there and they've got to make the best case. So almost kind of like the prosecutor saying, no, you want to leave that bit out, or, you know, let's not do that bit. Now, I know in proceedings, the prosecutor can say, you know, I object to this evidence. But when the prosecutor objects to certain evidence being given, he is objecting as a function of a lawful due process at the appropriate time through criminal procedure rules to the judge, right? What the Crown prosecutor is not doing is, you know, going to Assange or Assange's lawyer and saying, you know, come on. Well, you know, you'll take that bit of evidence out, you know, leave that bit out. Come on. You know, I'll try for a lower offence if you leave that bit of evidence out, you know, or whatever. That's doing a deal. That's illegal, because what they're actually doing is in respect to the person, the barrister, or to Assange's own conscience, volition, desired defence. They're basically it's not their business. Their business is to present evidence in front of a court to try prove something, not to get involved in the you know, the decisions of the decisions of other persons. You know, because then you might as well, you know, say that they're controlling the other person, their decisions. You can't do that. And if they have been doing it, it's become corrupted, criminal. You know, I don't really know how else to say it, but this is pretty much, in England, it's called favours. You know, if you put wanted posters everywhere, and it says reward £250 for any evidence against, you know, Assange, any member of the public who's got evidence can come forward and do that. But you can't do it for yourself, because if they had a wanted poster saying, you know, Assange, you know, reward £1,000 for any evidence against Assange, and Assange gives evidence to them against himself, right? And he gets the reward for giving evidence to them against himself. What happens, if they fines 1,000 and they give him 1,000 reward for giving evidence against himself? Then they've effectively paid for his fine. So if they give him if they give him $1,000 reward for giving evidence against himself, and his fine's $1,000, they've effectively paid his fine and got him to confess. Do you see what I mean? This is something that was worked out a long time ago. We were talking like the 1689 claim of right. When there's lots of when a lot more serious things were happening than just, well, it was a serious Assange being in prison because he shouldn't really been there because extradition really shouldn't have been allowed. But, when you've got, armies and soldiers invading, Scotland, and the general is being the judge and he's trying them without a fair trial, or he's trying to, forcing them to plead guilty or whatever, or without a jury, and all this kind of quite sinister abuses, corruption, unfairness, manipulating proceedings and things. It's part of that, and that's the reason why they're not allowed to do it. And I don't know what's happened to justice. The IQ seems to have lowered. This is what they were saying on Lawrence Fox, had that school teacher on, that head teacher, and he was saying, going to the staff room and you can't have any critical discussions or debates with any of the other teachers. They just switch off. They want to talk about X Factor or, Loose Women or morning TV or like really kind of like, shallow stuff. They don't want to debate or be critical about mathematics or the subjects or how the pupils should, behave or be treated or whatever. They're doing Parliament, but not really at an properly intellectual level, and you don't get any intellectual responses from MPs in Parliament. Rishi Sunak he doesn't want to give away too much. He doesn't want to say anything too critical. He doesn't want to say anything too controversial because then no one will vote for him. So Parliament, in a way, because of politics, because of a risk factor, because our politicians don't want to be intelligent and critical. They just want to spar with, loose comments, clever, witty comments that you've kind of got to unpack and kind of put together like some kind of Lego set. Like, oh yeah, I did mean something clever, but if you're clever enough to understand what I said was clever, but you've got to unpack that, but most people aren't intelligent enough to unpack it. Or get his innuendo, and what it actually ends up becoming is the reason that he did that is because he just didn't want to say it very clearly, and it becomes it's like dumbed down politics because there's too much of a risk factor. They don't actually want to do. They can't do politics. It's actually too risky for them to do politics because if they do politics, then they're at risk all the time. But that's the point. They're meant to be fiercely arguing against things that one party wants and the other doesn't. If you can't be critical about it, so it's almost like they've got this safety mechanism on, which is, you don't get the, if you've got, what's the point of having I'm not saying have guns, but what's the point of having guns if you've got the safety, catch on it all the time? You can't fire it. You can't fire these comments. You can't shoot. You can't, you can't spar. You can't spar. You're sparring like with foam. Timmy Mallet's mallet. Effectively, Parliament has become some kind of wackaday. Mallet's mallet. Jeremy Corbyn had a picture. I think it might have been on either Double Down News or something like that, Novara Media, or these big boxing gloves on, these big oversized boxing gloves or something, that's what it's come to, and in court, you're lucky if you can, if people know the law properly, know the legislation, know the procedure rules, so don't know how I got onto that from there, but I'll go back to this. This oath in America. So, yeah, you're not supposed to get involved with the defendant, or I would say the barrister. You know, the judges can omit certain evidence, but only through procedure when it arises. No, I don't think they can. They can't be, they can't. Your judge can't put the case together for the defendant, or start, picking at it, until you go in there and put it through procedure. And what these people are doing are, the CPS have a negotiating room in the courts, and sometimes they do deals with solicitors and lawyers, That could possibly be illegal as well. I've seen them go into the room and do negotiations. I've never managed to get in there and have a negotiation before, while I was in the waiting. Oh, no, I did. Sorry, I did go in there with Callahan, the speed camera expert, the laser guy. He was paid to turn up on behalf of the Crown Prosecution Service. So he was like a professional witness, but not a professional witness that, he's called up to the stand, and appears, in front of the judge, and the prosecutor asks him certain questions. Actually, he was negotiating with me in the room, in the little room, the little solicitor's room, in the court building, near where the foyer is, and he was going through the evidence, or whether the case could be pulled or not. That really is bargaining in a way. It wasn't through proper procedure in the courtroom, and that is when Callahan gave false evidence. That court's shut down now. That court's closed down. That's one of the 3 courts that closed down throughout the time period of my investigations, from 2013 to 2019, Chorley, Northallerton and Halifax, and they're beautiful buildings as well. Those 3 courts were very, very beautiful buildings. I like the buildings. You go into somewhere like Loughborough, it's almost like, some concrete horror thing. It's soul-sucking, it's corporate justice. It's horrible. Not these kind of like really old, ornate, antique, historic buildings where all these, legendary court cases have been fought and won, and all these, all these classic moves being pulled, magistrates court cheating going on, and documents pulled, and time's been written wrong by the clerk, and legend, maybe even duty solicitors, pulling out all the stops if they do a decent defence at the last minute for a defendant, and this and that, like when we're in Stockport, when I got on that driving course by fluke, which was a good. I managed to get the solicitor to do that at the last minute on the premise that education is better than punishment. The defendant, should be. We should put him on the, the driver awareness course. Oh, we'll have to ask permission from the chief constable. Oh, it's not up to the judges, is it? Oh no, that's a special course for special people. That's the sheriff's, the chief's special course for special people. No, the justices can't put you on that. Only the police chief can. This is it. It's sad that those courts closed down, those amazing buildings, and we're having to have these monstrosities like in Loughborough, these multi-storey car park justice. It's like it's like a multi-storey car park of justice. Oh, they got a pool table too. There's a projector on the wall here. A projector. Like at Chorley, like Wizard of Oz, pay no attention to the man behind the curtain, pay no attention to the man behind the curtain pulling all the levers, the big theatre room, it's like some kind of dark cinema room, all the chairs in the darkness and you're in the spotlight in the middle, you can't quite see, or like at Preston, when it's almost like, Who are these three justices? One who's got a Bermuda palm tree, shirt on. One who's got a palm tree shirt on. He's loose, like Fat Willie's Surf Shack, but he's quite, he's quite serious. He's some kind of committee man, loose committee man. Maybe he's a professor. Maybe he's an archaeologist. I don't know what he is. But he's got a palm tree shirt on. He's a volunteer, a volunteer magistrate. This is justice. He's not trained in the law, though, is he? And he's not a KC. That's the King's justices. This is just a magistrate's court. It's just it's like Skegness. I'm not quite sure if this guy's pulled off the beach at Skegness, or whether he's from some archaeologist committee somewhere, but he's a magistrate today. He's a palm tree shirt on. Well, actually, I'd like to use some special legislation about my political rights. Oh, do you really? Yes. Well, you wouldn't know about that then, will he? This is it. But anyway, so this American oath, absolutely, without respect to the persons, Well, in fact, this is what Assange's. Just a minute. The whole blocking of the extradition is based on the personal views of the defendant were political of nature, which they clearly are political when we make them political as well, when everyone's petitioning about it, like half the world, right? Make it into a political matter, but it definitely was a political matter anyway. The views of the person, which is ironic because if the views of the person are political and that bars Assange from extradition, right? Then how can those personal opinions and views, really, of the person would have to be included in the trial, and the judge can't have respect to the person and their views. Anyway, so that's an example why with this Assange being barred and it being political views, because courts and justices aren't supposed to affect or alter your political views. So if they are, it would be kind of like, let's say Assange, if Assange is publishing it for political views and opinions and it is political material, actually, that's why political material is protected, and that's why it's not really in the remit of the justice. In fact, that's a little bit like Hanningfield, because Jeremy Johnson KC, even though he wrote his paper off, he's using they're using the guilty plea to say, oh well, Hanningfield's pleaded guilty, so you might end up asking him some questions about Parliament, and then if you go into questions about Parliament, that would be parliamentary privilege, right? But he should have parliamentary privilege because he's like Hanningfield, not because of if his plea is, it's not like, oh, because he pleaded not guilty, you get to ask questions about Parliament, and then you can have privilege, right? No, you can't have it like that. And in fact, you can be prosecuted between sessions of Parliament, but only, well, fraud is a breach of privilege anyway, which Hanningfield's been charged with fraud, so, but then you've got the Magna Carta, which has been violated, and, it appears that's supposed to be tried in a Crown Court anyway. There's all that. But the fact is that, according to Jeremy Johnson's paper, if it had been, he's got a basic principle in there, although it's wrong because he's basing it on the plea, which is wrong. You can't do that because the right doesn't work properly. It will be almost like saying, can you have an ambulance or not, depending if you plead guilty or not. If you've got the right to an ambulance, it's completely separate from if you plead guilty or not. If you injure yourself in a courtroom, they can't say you can't have an ambulance because you pleaded guilty, or if you plead guilty, we'll let you have an ambulance. That's like privilege claim, more or less. That's the basis of it. It's a different aspect to the whole thing. but going by what Johnson did say, he said, oh, well, you're going on to this subject or matter of Parliament in the questioning, right? Which it's on that, it's on the subject of Parliament anyway, because, it's Lord Hangfield and his, dealings with Parliament in his financial affairs. But because his financial affairs are alleged and accused of being fraudulent, they can investigate it because, fraud's a breach of privilege, right? But if it hadn't have been fraud, if it had been something else, then they're not allowed to question him because it's parliamentary, it's political. So this is why, with Assange, with his publishing of his disclosing this, military, highly, it's the military is a department of federal government, so it's defense. It's defense, government defense, and it's, people need to know this, so they can, hold the government to account to it through the political system, so it's definitely political views and remit. So the judge cannot interfere with the person's own political opinions and views or pursuing them, right? So, and that is reflected in this oath here, with that respect to the person, right? So that's the person's conscience, effectively, like the jury's conscience. This is why the jury are meant to be able to decide, based on their conscience, right? Well, like in the William Penn case, we've got all that with Trudy Warner as well. So, yeah, he says without respect to the persons and impartially. You cannot possibly be impartial if you're telling the other person how they should or should not be pleading, or doing a deal with them to coerce them to plead a certain way. You're not impartial because you are. The prosecutor can assess the evidence and make their own personal decision if they want to prosecute or not, and decide what evidence they're going to present and so forth, and choose a line of questioning. But it's beyond their, it's beyond their legal rights to be. In fact, when I was at Leicester, I got, they would try to get me to plea a different way, change my plea. Or play a different way. They're not supposed to get involved with that. I mean, you can discuss that with your defence solicitor because you're paying them to advise you and make a case, or whether they can make a case or not. But even they really, aren't supposed to really change your plea or not, depending on what you think that you're guilty or not. Then certainly not the judge is meant to be impartial to all parties, right? You see, I think they can warn you, that if you plead not guilty, that it could be severer, but they're not supposed to do a deal with you in order to get you to do that, in order to get information out of you, or in order to coerce you to plea a certain way. And also, really, we're meant to have jury in a magistrate's court, but they pulled it out. And now you only get a jury in a Crown Court when it's more serious punishments, but everyone's scared of going to Crown Court because it's serious punishment. But you're more probably likely to get a fair trial in front of a jury, and if you tell the truth and are honest, with a jury in a Crown Court, then you're at a magistrate's court without a jury anymore, and with these pumpernickel magistrates who don't really know the law properly, and they're scamming us on rights, You're probably better. This is why Extinction Rebellion have been doing better in the Crown Court, because they've actually got a jury, and the jury's oath is meant to be, to acknowledge. They're meant to know all the liberties, rights, and privileges. The jury are supposed to know it. They did do in 1800. They knew what they had to. It's part of. They were. It wasn't a case law that arose in proceedings or was presented by either barrister. It was. It required knowledge along like I said all the whole way through. It's knowledge that is meant to be known to people, same as medical rights. Where's the first aid kit in the courtroom? All staff are meant to be trained to know that. It falls within that area of law, not what the barrister is presenting or not. That's why rights really you're not meant to be defending a charge when you're using a right. It's meant to be, okay, it's meant to be like a mention hearing type thing, like, or, a writ or just, that it's overriding objectives, regardless of what the charge is, or what act of law they're bringing the charge through. That's why your overriding objectives really aren't really in the acts. Some are, but only when it needs to be mentioned. But this is why it's in the criminal procedure rules, because it applies in every single case that you bring. You're recognising the rights of the individual, and that's why it's in the overriding objectives of the criminal procedure rules. Really, why the jury is supposed to know it, because the jury really are meant to know all the rights, privileges, and liberties. That's why they're in the procedure rules, and not in the act that is being used by the prosecutor, or in the material put by the defence case. Because regardless of what your defence case is, and regardless of what the prosecutor's case is, you always have the overriding objectives in to be recognised, which is reflected in the fact that the jury is supposed to know them all. So I think the American, who did this deal? Was it done remotely with, lawyers? Was it, who is it? I mean, is it a judge? Is it Biden? Is it Attorney General in America? And I think the Attorney Generals take the judicial oath. They definitely take the constitutional oath. We'll have to check. Someone in America's broken the law with Assange anyway, getting him to plead guilty. So, and like I've said, I'm not, I will say I'm not the greatest fan of journalists anyway, and all this new kind of surveillance state. Big Brother watcher against surveillance state for the government. It's enough with the government having surveillance state than has all been, perved at by journalists all the time. But when it's, serious things like, corrupt governments and things like that, you got to get these things right. This is, here is the oath. So, impartiality and without respect to persons. So, not based on not getting involved with the person's conscience, with their own free will. So that's it. I don't know really what else there is to do except, I would complain to Albanese or Biden. I don't even know what these, what Attorney General is. This Chris Carr guy they've got in not Nashville, in Atlanta. This Chris Carr guy. You get people like that who really haven't got a clue about constitutional law or rights, really.